All right, I'm here with Todd Stanton. He runs a practice that specializes in resources for small business owners, legal resources, HR resources, and the like. Thank you for joining us, Todd. I'm excited to talk about some of these questions that I get all the time on the podcast that I am not educated or really comfortable answering because we're all so unsure of these fine lines between what's allowed and what's not. So thanks for joining us.
You bet. I appreciate the opportunity. Thanks for having me.
Yeah. So go ahead and introduce yourself. And you're an entrepreneur yourself. You have a firm with nine individuals now working with you. Tell us a little bit about what you're up to.
So I started my own firm, my legal practice in 2011 after having spent a little over a decade in the towering prisons of big law in Midtown Atlanta. I recognized as I was leaving that big firm environment that all lawyers are self-employed anyway, and I might as well go out and start my own way and enjoy the fruits of my labor. I started it as a solo, and it was just me working out of the front of my house for a year. We added our first associate in 2012, and we've enjoyed pretty steady growth over the next almost 8 years, coming up in November. We now have 9 attorneys, 2 law clerks, and 3 support staff, including the recent hire that I'm perhaps most proud of, which is an operations director, so that I can get back to doing more business development and legal support rather than in the day-to-day operations of this business.
Absolutely. Congratulations on the success. And it sounds like you're really filling a need. So you get a lot of calls from small business owners who are in trouble. And let's talk about some of those calls that you get and some of these common questions that you think a small business owner, whether they're 10 years experience like me, who's just not quite sure about this and maybe got lucky along the way, or somebody who hasn't even started a business yet, and some things that they need to really know to button down and do the right way off the bat.
Sure. Well, I enjoy this, talking about these topics a lot. The sooner we get small and medium-sized businesses out ahead of these employment issues, the better. They are not rocket surgery. It is not difficult to do. Nobody has graduated first in their class from law school and become an employment lawyer. It's not mysticism over here. It is the same issues coming up over and over and over again. And it's frustrating to me sometimes that I have to answer these questions over and over again, recognizing that it's these first time that most of these people have heard this, right? Mm-hmm. Let's start from the proposition that no matter how well-intentioned an employer is and how well they think they're going to be running this business, you're going to have 5% of your employees who cause 95% of your problems. Mm-hmm. And the sooner we can flag those 5%ers as problems and move them on to let them be somebody else's problem, the better off you're going to be in your work environment. 5%ers, they're low productivity to be certain, but they're also disruptive. They take up too much management time. Everybody else knows who's not pulling their weight, and the 95%ers who have to hang out with 5%ers leave. And that increases I'm not a math major either, but it increases the percentage of the 5%ers. And the more you don't deal with the 5%ers and get those poor employees out, the sooner that you can, as soon as you can, the better off you're going to be. So starting from that proposition with 5% of employees causing 95% of the problems, those 5%ers are going to be bringing up the legal claims that we touched on here today. And the first one that if it's not on your radar screen today as a small business or a medium-sized business owner is the Fair Labor Standards Act. It is more than half of my practice. It is handling 4 to 5 of these matters a week on new intake, and it is a law that plaintiffs' attorneys are absolutely eating up. There were
8,000 federal suits in 2017 against small business owners and I guess business owners of all sizes.
And I looked yesterday. We get a news service that pulls all of the federal complaints that were filed in our district, the Northern District of Georgia, and there were 4 of them filed yesterday. And they're not against, some of them are against Walmart, some of them are against Microsoft, some of them are against Target, right? But a lot of them are against
Storage Squad.
Sure, storage. A lot of them are against, the local tire repair place. A lot of them are against software startups. It is a law that was written back in the 1930s. It is, unlike other employment laws, it is applicable to almost every employer that there is. If you have more than $500,000 of revenue, or if your employee engages in interstate commerce, this law is going to apply to them. And broadly stated, it is that every employee gets $7.25 for every hour worked, minimum wage. And that's subject to other jurisdictional issues, right? Certain states or municipalities have higher minimum wages. But the federal law requires $7.25. And it requires that they get paid overtime for hours worked in excess of 40. They're entitled to 1.5 times their regular rate for hours worked in excess of 40.
No. Okay, so that's the big one. That's the big one. Is it overtime? Is it your number one mess up?
Yes.
Because small business owners, they get busy. They don't have time to hire more employees. They're not paying attention to how many hours these guys are working or gals, and they overdo it.
It's that, but more importantly than that, it is making the common assumption that we'll talk about the contractor employee distinction in a minute, but it is the common misconception that if I pay somebody a salary, I do not have to pay them overtime. Mm-hmm. And that is not the important distinction. The important distinction is if they are exempt from the law, you don't have to pay them overtime. And the handful of relatively narrow exemptions from that are commonly misapplied. So there are 2 tests to determine whether somebody is not entitled to overtime. Number one, they have to earn a salary of at least $455 a week. So you have to pay somebody who you are not going to pay overtime at a salary of at least $455. Now that's
going to come out annually.
Yes.
Quick math.
That comes out to be about $26,000.
Okay.
But that's not a barrier to avoiding overtime, right?
Yeah.
But that's never really an issue. Incidentally, that's getting ready to go up later in the year with some regulation changes. That'll go up to about 46, I think is what the number is.
Okay.
That's not where the problems occur though, because you have to not only have the salary element, you also have to have that employee performing certain duties. They have to pass a duties test. There are a limited number of those. And if you don't fit into those duties, the employee gets overtime. Okay. So the first exemption is the professional exemption. Doctors, lawyers, architects, engineers, CPAs, dentists, right? It is not dental hygienists. It is not paralegals. It is not somebody with a master's degree, right? They are professionals. They have to go to school for an extended course of study and then actually practice that profession in order to be exempt under the professional exemption.
All right. So let's just, for all common assumptions on the people listening, let's assume that one, we're not hitting that one.
Not going to hit that one. Mm-hmm. So the next one is an executive exemption, right? Which is somebody whose primary job responsibility is to manage a recognized department of 2 or more full-time equivalents. And they have to have hire, fire, disciplinary authority for those individuals or significant weight given to their opinions on them. That's a supervisor exemption. That's a manager exemption. What it's not is it's not an assistant manager exemption. So if you've got an assistant manager, if you've got just a foreman who is kind of bossing people around at times when the real supervisor isn't around or when the manager takes vacation, that's not their primary responsibility, and they are not exempt from overtime and entitled to time and a half for hours worked in excess of 40.
And most of the time they're not overseeing 2 full-time employees in a lot of these small businesses. That's the big one.
Yeah, that's true. In fact, I just am settling out a case right now in which a woman who was hired as a quote unquote manager was really just a project manager, right? So she wasn't necessarily overseeing individuals. She had a manager title, but she was overseeing a process. She was overseeing the implementation of a product that doesn't qualify her as for that manager's exemption, for that executive exemption. And so they're looking at having to pay an overtime claim for her. We'll talk about how that comes about in just a second. But with all of these are very narrowly applied exemptions, and somebody who doesn't manage those 2 folks doesn't fit it. Mm-hmm. The next one, and perhaps the most commonly misapplied one, is the administrative exemption. The administrative exemption exempts folks who has as their primary responsibility white collar work and they're endowed with significant discretion over matters of import to the company. So in this instance, in a bigger company, think about a chief human resources officer, think about a chief financial officer, think about your head of accounting, somebody along those lines who is actually making and implementing the policies that run the business. They're allowing other people to make the widgets, and they're running the business to allow them to do so, right? Other people make the widgets. They're outside of this doing the white collar work to run the business. That one is commonly misapplied because it doesn't apply to an accounting clerk, right? It doesn't apply to an inside sales rep, right? They're making widgets. It doesn't apply to the administrative assistant.
Basically, any employee that is customer facing in a service business as well, like a lawn care crew leader, a foreman on a construction company, those type employees.
Yeah, so I mean, you got to look at what that primary responsibility is, okay? And there's a couple other exemptions. There's an outside sales exemption if the person is regularly traveling and making contracts for sales of goods or services at a customer's place of employment, they might qualify for an outside sales exemption. There's a computer professionals exemption where if you're designing networks, if you're writing code, right, it's not your help desk, right? It's your high-end network engineers, your software engineers who are going to be exempt. And with those 5 exemptions that we just got done talking about, that's about it, right? Mm-hmm. And when you're looking at whether or not to decide whether or not you're going to pay somebody overtime or not, fewer people fit into those than you think as a startup, right?
I've heard people cite a seasonal employee exemption as well. Is that still around?
Yeah, it is, but that's even more narrowly applied. That's for more like amusement parks or recreational facilities, right? Mm-hmm. It does not have to do with, and it may apply to a Christmas tree lot. I can see that happening. Mm-hmm. But for the most part, that's not going to be something that folks can rely on. I'll point out that in 20 years of doing this, I've never had a seasonal exemption come up. So that's not where.
So snow plowing and lawn care doesn't count.
Up in the north, I can see how that may work, but it has to do whether an employer qualifies for that exemption has more to do with what amount of revenue comes out of those certain seasonal months. Mm-hmm. So snow plowing and lawn care in the Northeast or across the Midwest, that may be there. I just haven't looked at that. Yeah. I'm in Atlanta. We have lawn care 12 months out of the year, and our snow plowing business is not thriving. Lean snow plowers.
Okay, so basically, let's assume a lot of people are messing this up. What are the risks here, Todd?
So that's a great question, and the first risk is that the hours that need to be paid on this very rarely amount to much, right? I mean, if you're dealing with a $20 an hour employee, half of their regular rate is $10 an hour. How much overtime are they actually working? 100, 200, 300 bucks a week. I mean, that's not that big of a deal. The Fair Labor Standards Act requires that if you haven't paid people properly, that you have to double that for liquidated damages. So if I owe you if I haven't paid you properly and then you catch me on it and I owe you $1, I owe you $2 under the statute. Okay, that adds up, and it can be a nuisance to be certain, and can certainly impose some cash flow difficulties. But the real leverage that employees and particularly their lawyers have with respect to the Fair Labor Standards Act comes from the attorney's fees provision in the statute. This is in essence a private attorney general statute that is looking for private enforcement of these wage and hour laws. And in order to incentivize plaintiffs' counsel to take these cases that are even have a marginal return, they get all of their fees if $1 is paid. And so that provides an enormous incentive for these plaintiffs to bring suit on marginal amounts. And if a suit is filed, my reasonable hourly rate is $355 an hour. Mm-hmm. So if we're arguing over $10 an hour and you're paying me $355 an hour, and I can't say for certain that is a slam dunk exempt employee, you could very easily turn this into a $500,000 proposition by the time you pay my fees, whatever damages there are, and the attorney's fees on the other side.
And looking at this as a business owner, I mean, what really is going to settlement, right? They know that you have to go to settlement. They know that you cannot afford to go to court and actually fight this. So they kind of have you there. Like, you don't have many options.
No, no, it's absolutely not. And they understand, plaintiffs' attorneys understand that. I mean, they understand how it goes, and they make leverage demands, right? And they come up with some inflated numbers. But the way I like to say it is the case never gets cheaper than the other side's last demand, right? I mean, it doesn't get any cheaper than that.
Because they have 100% of the leverage.
Yeah, 100% of it. And if you put all of your defense eggs in an exemption basket, right? So I think this person really was a qualified, administratively exempt employee. Well, you better be willing to risk $500,000 in order to avoid having to pay the 70 that they're demanding.
You still got to pay your attorneys as well.
Yeah.
So the moral of the story here is to take the steps to do this stuff right. So let's talk about what we can do as a small business owner to get this stuff right.
Yeah. So I just clicked down a couple on the number 4, but the first one.
I'll share the slide as well here in the show notes at sweatystartup.com. I'll put a copy of Todd's slides here of kind of the bullet points that we're discussing right now.
What we're working on. Good. So the first one is that we need to make sure that employers are not using the independent, quote unquote, independent contractors interchangeably with employees. Right? That is a matter of law. That is not a matter of agreement. So even though your workers want to be considered contractors, they want to be paid on a 1099, they're happy getting a straight hourly rate for all hours worked. They're fine with no withholding. You're fine with not matching. All of those other issues are great, but that is not the law. Once that starts coming unraveled, the contractor who you thought you didn't owe overtime to becomes an employee, and then you do owe overtime to, as well as some tax penalties and workers' comp issues and some unemployment issues that all come creeping out. And you don't know where that is. So let's start looking at whether or not you really have employees rather than contractors.
Yeah, this is a huge one in this business. I mean, people, to pay an independent contractor, you can pay $15 and the employee sees $15. They don't quite understand the tax implications that the employer is actually covering some of their payroll taxes and things like that. But this is the big one. This is where it kind of throws off competition. If one guy down the street's doing it right and he's paying his guys $15 an hour, it costs him $19 an hour to do that, whereas the employee's only seeing $12. It's not. I'm glad to hear that it's not a matter of choice because, let's talk about it. Let's dedicate the rest of this episode to the independent contractor employee. I guess you would call it a debate because there's been so much in the news about Uber and Lyft and so on. But let's talk about how we should frame this as a small business owner.
So you say it's a debate, and it is an interesting academic debate. And current case law coming out of the gig economy, whether it's Lyft or Uber or Grubhub, is certainly loosening the constraints on small and medium-sized businesses in order to use these contract workers, to use non-employment labor, right? It is and always will be, though, the more conservative legal play to consider them as employees. And when I get folks who want to take the risk and who want to use contractors instead of employees, most of the time when I ask them why they want to use contractors rather than employees, the reasons they give don't hold water, right? Why are you wanting to use contractors? Well, I don't want to mess with all of that withholding and tax stuff. Well, no kidding. Nobody does, but that's not a reason that the government's going to allow you to just designate them as contractors rather than employees. Well, I don't want to mess with overtime. I'd rather just pay them a straight hourly wage. Again, no kidding. Nobody wants to do that, but that's not a good reason to use contractors instead of employees. So that's one side of it, that they're leaning into the exact reason that they should be considered employees. The other side of it comes out where they say things that don't matter, such as, I want to be able to fire them whenever I want. Well, in most states, it's an at-will employment relationship anyway. You can fire an employee just like you can get rid of a contractor, right? Mm-hmm. Well, it's temporary work, and I don't know whether they're going to be around for a long time. Again, that's a good point, but it's also not one of the factors that determines whether or not somebody is a contractor or an employee. The lists of tests of factors that go into whether somebody is a contractor or an employee Every agency has their own varying test of, and they're all non-exhaustive lists of non-determinative factors, which is just nothing but discretion, right, and argument.
It's tough. It's tough stuff.
And when you hear, as a business owner, when you hear something about it that's creating room for argument, you just need to hear cash register bells going on, right? So my advice is pretty consistently treat these folks as employees, do what you're supposed to do, and don't take the risk of a misclassification penalty. Not only do you have that Fair Labor Standards Act problem that I was just talking about, you've got tax liability. If you're paying somebody on a 1099 and it turns out that later that they should have been classified as a W-2, all of your 941s, all of your tax reporting has been wrong for the past however long you've been doing it, and you're going to face penalties and interest on that. And something unique about that tax liability, as well as Fair Labor Standards Act liability, is there's no LLC protection. That goes directly to the owner of the business. And so if you have not paid your employees properly and you think, well, screw this, I'm just going to bankrupt, well, you better be willing to personally bankrupt too, because they're going to come after you. They're going to sue you individually, and they're going to take your house.
Wow, that's a big one that people really should be aware of, that the LLC veil does not protect you in this instance. And also,
or the tax liability.
Yeah,
right?
Wow. And also the risk of injury is the big one for me. When I'm using an independent contractor and they don't have workers' compensation insurance, and we're doing a lot of physical work out here. We're lifting boxes, we're driving trucks, we're in warehouses. Talk a little bit about the injury side of it.
So that's where one of this comes up. So we can go along great, right? You're paying your contractors an hourly wage. They're happy because they're collecting all of their paycheck. Everything is going good. You've got good leverage over your competition who's doing it right. But you never know when it's going to fall apart. One of the ways it falls apart is what you just said, where somebody twists their ankle, somebody drops a box on their foot, somebody sprains their back, and they don't have workers' comp insurance. Well, they might not be as up to employment law speed as we are, and they go talk to, I like to say, Morgan for the people, or whoever their local plaintiff's attorney is.
Local billboard guy.
Yeah. And they go in with a workers' comp injury. That plaintiff's attorney not only says, well, you probably weren't a contractor, you're probably an employee, but also let's talk about how you're paid. So we run right into the Fair Labor Standards Act issue, right? And recognize that when there becomes a dispute about a contractor or an employee, the employer, the company, has lost its best witness as to whether that designation is appropriate. They instantly are now arguing against them, who now has a self-interest in making them an employee relationship, not a contractor relationship. And it's very easy for those individuals, no matter how educated they were about the scenario going into it, to say, oh, I didn't know, he was just paying me this way. I didn't have any idea that I thought I was an employee all along. The other way that it happens is we terminate somebody from a contractor and they go file for unemployment. They don't know that they don't get unemployment because of that. They just go down to the State Department of Unemployment Benefits, and then suddenly we're dealing with that same argument there, right? If they feel they've been discriminated against, go to a bus side lawyer, go to a plaintiff's counsel. It's not going to take them long to penetrate that contractor-employee distinction.
And once again, the leverage is in the other side. So
100%. It's all in the arguing about these things.
Mm-hmm.
Right? Honestly, I shouldn't say my entire practice. The bulk of my practice deals with contractor-employee issues, FLSA issues, and even in these other employment disputes, it is coming to a number with the other side that allows my client to get back to work as soon as possible. It is purely the argument that does it. I send my kids to private school because of people who want to argue on principle, because all that does is ring the bell. Getting out of these things is the best way to do it.
And really getting out of them before you even start is what we're trying to promote here. So if somebody is going to make this distinction and say, I am using contractors, maybe it's a cleaning company, maybe these employees are literally advertising their services and doing work for several companies. What are some things that we as business owners have to have in place? I know we could talk about the 10 questions and the distinctions all day long. I don't even want to go down that rabbit hole. People can do their own research. Mm-hmm. What's your advice, Todd, for a cleaning company that wants to use independent contracted cleaners instead of putting them on the payroll?
All right. Well, the first advice is going to be classify them as employees, not as contractors. But once you tell me that your business can't survive that way and you're making the informed business decision that you're going to keep them as contractors, right, rather than employees, we'll work to try and get that there with a huge disclaimer in all of our correspondence that we're telling you to go the other way. It's that serious, right? Mm-hmm. The first thing is, let's stop calling them independent contractors. That term is just loaded. And if you go to any plaintiff's counsel, if you go down to the Department of Labor, if you go to the Federal Department of Labor, if you go anywhere and start talking about independent contractors, that's going to be a red flag that this person is misclassified. So, and as a pet peeve, you can't identify to me what the difference between an independent contractor and a contractor is. So it's just a term that's thrown around very loosely. We start using the term vendors, right? So we don't have independent contractor agreements. We don't have contractor agreements. We use vendor agreements.
I like that.
That is less likely to raise the attention, other than on your now increasingly popular podcast, Everybody Knows My Secret. So we start using vendor contracts. And that written vendor contract is necessary but not sufficient in order to start arguing that they are not employees, right? Because remember, once this falls apart, you've lost your best witness. And so having this agreement in place that sets out they are not employees, that they are truly vendors, that they are free to perform work for other folks, that they are paid on a project rate, right, or something other than wages, that they're responsible for their own taxes, they're responsible for their own insurance, that they're responsible for bringing all their own tools and equipment, right? So we go ahead and lay out all of the elements of what makes them a non-employee in that agreement. That being said, that's still not going to carry all of the water every day, but it's certainly going to be necessary, even if it's not sufficient to do. The other sort of threshold issue, and this becomes a little bit more of a pain in the neck, is if there is any way to get that vendor contract associated with somebody else's federal employee ID number rather than a social security number, such that at the end of the year, when your accountant or payroll service is sending off all of the 1099s, that they're going to that vendor's tax ID or federal employee ID number rather than a social security number, this starts to look more like a contractor relationship. It's business to business. So
having that contractor create their own LLC or making sure that they do have one, that always helps.
Yes. I don't want to be too cynical about this, but a lot of this distinction is cash flow, government cash flow interest. Mm-hmm. And so if they understand that that LLC is filing their 941s and making their quarterly withholding payments, that's going to solve that cash flow issue for the government.
Tax evasion is a huge part of this because people get paid on 1099, people get paid in check, and they don't pay taxes.
Mm-hmm. And if they do, it's once a year, right? Mm-hmm. So we know how voracious government spending is. They like us paying that quarterly taxes, right? Mm-hmm. Again, that's sort of a side note there, but at least you're taking away one of the elements. And if you can get them to a federal employee ID number, that's a big thing, right? Mm-hmm. But also from all optics, they become more of an official business at that point, right? Mm-hmm. Another thing that you can do is making sure you are all in or all out. If you have some people doing a job and they're employees and some people doing a job and they're the same job and they're contractors, that's going to default back to you've acknowledged that the employment relationship is appropriate. That's what's going to teeter that over. So if you're going to go the contractor route, go all in the contractor route. But honestly, in most circumstances where you're trying to do this, the biggest hurdle you face is that the contractors you're hiring are doing the work that you're supposed to do. If you've run in a landscape company and you're hiring contractors to mow the grass, that's in your line of work, right? I mean, that starts to look more like an employee relationship there. If you hire painters to come in and paint the landscaping office, well, that looks like a contractor relationship because it's not in your line of work.
But if you're a home cleaning company that specializes in getting Airbnbs ready to re-rent and you're using all contractors to do
that's going to be a problem. Mm-hmm. Yeah. And one of the most frustrating parts of this is what you touched on earlier about the guy up the street who's not doing it properly and is continuing to make a mint while you're complying with the law and taking a bath. Mm-hmm. And I wish I had a better solution than that. other than to say the Department of Labor has an anonymous tip line, right? I don't say that lightly. I don't say it. I understand the implications of that, but there's no business defense to a misclassification suit. You can't say everybody does it this way and hope to win the day. Industry practice is a minor factor, but it's not gonna win you what you need.
I like everything about this. So thank you so much for coming on the show. I'd love to have you back on because we've got so many more important things to talk about. And honestly, we're going to have some questions come up about this episode. But how can people find you, Todd? First of all, for the people who are setting up a business or they have a business, they don't have any problems yet. They want somebody on your team to look at their systems and say, hey, you should be aware of this, or hey, you should be aware of that.
So yeah, great question, and I get to the contact stuff in a minute. One of my rules of thumb is to remember that it is always easier to apply new employees to existing policies rather than to apply new policies to existing employees. So the sooner you get the HR groundwork in place as you're growing, the easier it's going to be for people to adapt. If you start having a work environment in which you've got Maxim magazines laying around and it's a lewd atmosphere, you got a keg in the office and all of those other things. And as you get bigger and start recognizing that maybe we need to button our HR house up, it's going to be a lot easier. And it's going to be a sad day when you wheel that kegerator out of your break room because of all the people who've come to rely on that as part of your culture, right? Figuring out what the culture is and then getting some policies in place early is better. And I don't understand why folks just think HR is going to take care of itself. They get an accountant, right? They get a commercial leasing agent to help with their first space, right? They do all of these things. They get an attorney to help with the corporations, but yet they somehow think that all of this payroll and all of the HR issues is just going to magically fall into place. And it doesn't. I'm barking a little bit to get a HR seat at the table early on. I like corresponding via email, todd.stanton@stantonlawllc.com. And my office telephone number is 404-881-1288, 404-881-1288. And we're on the web at stantonlawllc.com. And there's a blog site up there too, if you can search it.
And you guys do work with a lot of businesses that just want to set this stuff up the right way and that don't necessarily have any problems yet.
Yeah, our job is to help them get off on the right foot. We have lots of different ways to price that so it's not as nearly as intimidating as working with a traditional law firm. Our business is such that we know what your pain is, and we know that we're pure overhead, so we're sympathetic to that. We have lots of different ways that we can space that out. It honestly, it sounds cliche, but it's more important that you get this information, because if you don't, you're just going to be whistling past the graveyard until it hits you. No one is immune from an employment lawsuit, and a lot of this stuff we can take care of on the front end, or at least prepare you for what's coming.
Well, that sounds great, Todd. And you're located in Atlanta. Do you do remote work with clients all over the country, or how does it work that way?
Of course. I mean, we're able to counsel and advise on these, certainly on the federal employment law issues, no matter really where anybody is. If we have to appear in front of a court, or if we start getting in some sort of adversarial relationship with one of the employees in there, we might need some local counsel involved in this. But we're not bound by any geographic limitations on the counseling part, which is really where we are. If we get into litigation, everybody's already lost.
Oh yeah, the goal is to avoid that, as we know. So yeah, that sounds great. We'd love to have you back on here to talk more. Hopefully some people do reach out and I can send you some business. I know I don't have a whole lot to offer as compared to your billable hour rate, but we really appreciate the time. Thank you so much.
You bet. Let me know how I can help, and I'll look forward to hearing from you guys again.
All right. That was great.